And I'm wondering, aren't we excusing this? And what is this going to tell the students? Isn't it going to tell them, go ahead, kill people, burn everything you want, don't worry, after eating you good, you clean?
One thing we're not excusing, because the excusing would be if this child did these things and you say they are children, we can't even take them to court, you see.
Welcome back to Ask the Experts, viewers. Karibuni sana, where we answer your questions from a totally expert opinion. And on this one, it's really expert because I know very little about law. And then definitely matters that touch your heart, matters parents, matters family. And just last week, there was a tweet by DCI about the fact that students' crimes will actually remain a permanent record on their certificate of good conduct. We'll be looking into that with an actual lawyer. So I'll let our lawyer introduce himself.
I'm Bobby Mkangi. I'm a lawyer by profession and training. I work as an independent consultant on governance issues and human rights issues, but particularly also on children's issues. My strong background is in child protection, children and the law. And it's actually my work in children and the law that gave me the opportunity to be a member of the Committee of Experts on Constitutional Review that drafted and prepared the Constitution of Kenya 2010. So I'm happy to be with you and to deal with this important issue concerning our children.
Yeah, it's really important. And the first question on everyone's mind is it even constitutional?
The Constitution of Kenya protects every person in Kenya. The first article of the Constitution, and that's after the preamble, and the preamble is the part that captures in a very poetic way, inspirational way, our history and why we came up with a new constitution, where we say we bequeath to ourselves and to the future generations of Kenya this constitution. And we begin with the words, we the people. And children are people also. And Article 1 says all sovereignty belongs to the people of Kenya. Children are people, they are persons, so sovereignty also belongs to them. But more importantly, when you look at Article 53 of the Constitution, talks about the rights of children. In fact, that's one of the very important departure or differences between the former constitution and the current constitution, in that the current constitution specifically and categorically recognizes children and protects children. When you look at Article 260, which defines different words and phrases and terminology used in the Constitution and in other laws, the Constitution actually is the one that defines who a child is in Kenya. And it says that any person who is under 18 is considered a child. So children are very much part and parcel of the Constitution because they are Kenyans, they are human beings, and sovereignty belongs to them. And in fact, the Constitution is more important to children than even to us adults, because how we implement it now determines their future, you know. And that's why we have to look at the Constitution and implement it in the way it is supposed to be, because if we get it wrong, we are setting up ourselves for a future, for our children, a future that is not very, very, very good. Specifically also, as I was talking about Article 53, you find specific wording that protects them within the criminal justice system, where we say that children are to be treated differently when it comes to the criminal justice system. And that's why, and it's not only in Kenya, all over the world, you find that there is a broader criminal justice system, but there is what is called the children's justice system or the juvenile justice system. And it comes into play because we recognize, and this is recognized from a sociological, from a psychological, from a child development and human development perspective, that children are different from adults. Sometimes people think children are miniature adults, or they are small adults, or vice versa, that adults are big children. Yeah, some of them behave like big children. But children, and even from a scientific viewpoint, as I've said, when you look at development aspects, are different from adults. And that's why they are specifically dealt with, in a different manner.
So is there something that specifically points at children in the Constitution with regard to their criminal record?
Article 53 has different provisions. Without dealing with them very specifically or ad verbatim as is written in the Constitution, I will talk about them generally. First, there is a principle of what is known as the best interest of the child, that whenever any person, and this includes institutions, state organs, parents at home, teachers, whenever we are dealing with children, we must deal with them with the guidance that their best interests are paramount. So you look at every child and the specifics of the circumstances that attend to that child in the context that the child is. And that is what guides you to make a decision. But secondly, the rights of children to privacy are also protected. Thirdly, you find that the Constitution says that children, when they are dealt with as child offenders, their rights are to be protected. They are not to be, imprisoned. They are supposed to receive justice without delay. They are not supposed to be punished in inhumane and degrading ways. And so that sets the principles of how we look at children and their rights in our country, Kenya, Article 53. But we also have specifically the Children Act. And the Children Act, which actually came before the Constitution, because we enacted the Children Act back in the year 2000, but it came into effect in 2001. So the Children Act is the one now that has the detail of how we deal with children. And you find a specific part that deals with child offenders. When somebody who is under 18 has contravened the law. Because yes, we agree that children, in as much as they are children, they can offend the law. But when they do that, how do we treat them? And it comes from that principle that I told you, that children are different from adults. The Children Act will talk about children's privacy being protected. It will even go to the extent of saying that when you're dealing with child offenders, when a court, and for that matter, a children's court, that's why we have children's courts. When it arrives at the decision that the child is guilty, we don't even use the terminology guilty. We say there's a finding of guilt. And we also don't say that the child has been sentenced or convicted. We say the court gives an order upon the finding of guilt. That language is different because we do not want to say we are convicting children and we are holding a child guilty. So you can see the Children's Act, borrowing from the Constitution, is very specific in the way it wants to treat children, even when they have offended the law. And that's why it creates special institutions like the Children's Court, where children are dealt with separately, away from adults. It has specific language, like I said, language that does not stigmatize the child. It has different ways of dealing with children. Children are not imprisoned in Kenya. Children cannot be given the death sentence in Kenya. That's why children are dealt with, using orders like probation orders, sent to probation, Boston institutions if they're above 16, sent to rehabilitation schools, which were formerly known as approved schools. They can be given community service orders to go and do some work in the community. A court may decide that perhaps counseling, is a better option. So you can see why all these things have been crafted.
Because they are children.
Because they are children.
So does that mean, Bobby, that it's actually not right for the DCI to say that?
In fact, it is unconstitutional. It is illegal because as of December last year, the High Court in Machakos did deal with this issue. This is December 2019, and pronounced that because the DCI had wanted to, put the records of a certain child who had been charged with the murder, that these records would permanently. And fortunately, this child challenged that decision by the DCI, and for that matter, the state and the Inspectorate of Police in Kenya. And the High Court, looking at international law, because again, when you look at the Constitution, in Article 2, we say that where we have ratified international treaties, those laws are part and parcel of Kenyan law.
We actually subject to any law.
Yes, and especially those laws that we have ratified, and we have said we are going to implement. And when you look at children, we have what is called the United Nations Convention on the Rights of the Child, which Kenya has ratified. We have the African Charter on the Rights and Welfare of the Child, which Kenya has ratified also. We have guiding laws and principles like what is known as the Beijing Rules that deal with children, child offenders generally. We have what are called Riyadh Guidelines, which deal with children, child offenders in custody. And they give guidance and principles of how children should be treated. And you also look at other jurisdictions, other countries, and how they have dealt with children. And that is what guided the court, the High Court, to decide that the decision by the DCI, and for that matter, the police and the state, to permanently hold the records of children who have offended the law in their records is unconstitutional and illegal. Wow. So it's not even that it is in our law books alone. It has been dealt with courts, and the courts have declared that it is unconstitutional and illegal. So the records of children should be expunged at the time when they get 18.
At 18, whether they've served their sentence or not.
Yes, and before that,
they're no longer criminals on record.
And before that, because of the issues I was talking about in terms of privacy, that's why even when you go to cover cases to do with children, you don't, put anything that would lead to the
or even their faces
or their identity coming out. It's to protect them, and it comes from the principle that the juvenile justice system, the children justice system, operates from the guidance that children are still developing, they are still growing, they are still very much impressionable. When you look at teenagers, 14 to 18, that's where peer pressure, is paramount. That's when we still cannot effectively make decisions at that age. And you also see it attended in other laws. That's why you're given an ID at 18. That's why you can only marry from 18.
Yeah, true.
That's when you can, have a drink in a pub.
You're not considered to make such permanent decisions in life.
And so when you offend the law at that age, the primary focus of the correctional services is to reform.
Not to condemn.
Not to condemn.
Yeah.
So the child is supposed to be reformed. And actually there are studies that have shown reformation of children, of child offenders, works better and is practicable and achieves results compared to adults. Yes. So it is something that is informed by science and studies that have shown that it is possible to reform. So if you condemned a child for something that he or she did,
even at 17,
even at 17.
Does it mean we are excusing these people for age because of their age?
Yeah.
So we are excusing them from really deserved consequences, so to speak, because some of the things they are doing, and with this rising number of such, grave cases where students are almost murdering their teachers, they're burning things. I have been in the middle of a case where a student set a dorm on fire and 3 students died. And I'm wondering, aren't we excusing this? And what is this going to tell the students? Isn't it going to tell them, go ahead, kill people, burn everything you want? Don't worry, after eating, you're good, you're clean.
One thing we're not excusing, because the excusing would be if this child did these things and you say they are children, we can't even take them to court. You see, they still go to court. They still prosecuted. And where they are found to be of guilt, that finding is held. And then there are consequences in that they are sent to institutions, like rehabilitation schools, Boston institutions, and whatever else measures that the court would find fit for that particular child, so long as they're not sent to prison, so long as they're not sentenced to death, because the law does not allow that. But the focus being sending the child to an institution that can allow the child to bear the consequences and reform where possible. So there is no excuse. There is no, in fact, the only children who are excused are children who are under 8. The law says that children, as it is right now in our penal code, children under 8, when they commit an offense, we don't deal with them criminally. You cannot charge them in a criminal court. And then when it's between 8 and 12, the court has to examine first whether this child has, competent capacity to be able to commit the offense that the child is being charged with. When you look at the consequences of a certificate of good conduct or the lack of it in this country, it means you have no life.
Yeah, in fact, on that warning, DCI is usually careful to say that students should be careful, as no employer will be willing to employ. And actually that leads me to the question somebody asked on Twitter when they were saying, this is very unconstitutional. And they asked outrightly, where does DCI get the guts to spell out these warnings all the time, if really it's not something that they should do?
And that's why I'm surprised that the DCI did spell out this warning again, because there is, as I said, there is an authority from court beyond the laws, beyond the science, beyond the global outlook on this issue. The courts in Kenya have pronounced themselves, and that is the position.
So actually, going on to something not very different, because it's still about students, when you talked about the children are really, they have a place in the Constitution. And one of those places you mentioned is justice without delay. And someone has an experience of a student who was involved in arson, which actually resulted in murder. But they don't even understand how that case went, because it was only 2 years later that there seems to be actually something going on with the case. We call them witnesses, and people are not even appearing because it's been so long. They feel they contradict themselves in the statements they wrote, and they're asking, was that constitutional? What were they supposed to do?
There's a difference between, again, a student and a child.
They were under 18.
Yeah, because if the student is over 18,
they're not a child.
They are not a child. So they'll be treated
like an adult.
Because we have, an 18-year-old who is in Form 2, Form 1, others in primary school. So if they commit an offense, they will not rely on the fact that they are students. It is the age that is looked at. So that's very important. So if a student commits an offense, but he or she is an adult, they'll be dealt with as adults. On the issue of justice without delay, even the Children Act has specifics in terms of how long cases should last. And if it's minor cases, if it actually goes on for 3 months without the case ending, it should actually be dismissed. If it's a major case like murder, which attracts capital punishment, murder, robbery with violence, after 6 months, it's actually supposed to be dismissed. But yes, we know our justice system
Yeah.
and the delays. And
Yeah.
But I think if our lawyer who is attending to the case brings the issue or raises the issue in court, that this case has been going on for this long, and I'm asking the court to dismiss it because it has breached the timelines, then the court can consider that and the reasons why. Because again, this comes into play because there was I forget the name of the poet, but he said that, a child's time is now.
Yeah.
Because a child is developing every second.
Quickly.
That's why the demarcation is made at 18, because the scientists have studied and seen that it's at 18 that we others, I mean, plus or minus,
Okay.
but majority at 18, that's where our bodies develop, our minds, are
We
fully
calm
developed.
down,
Yes.
yeah.
But before that, every day you're growing, you are changing. And so a child cannot wait. So if you delay a child's case, the child needs to be in school. The child needs to play. So you deal with the case very fast so that their life can go on, even if it's being sent to a rehabilitation school, a Boston institution, that does not affect other rights. We have to remember that, and why we don't hold children responsible, it's because of their diminished responsibility. And so because of their diminished responsibility, so who has the full responsibility? It is society. It is society. So where you find children burning schools, killing, and doing all these sorts of things, engaging in sexual
Harassment
and violence and abuse of other children, and we have to ask ourselves, where are they learning? Because children are learning.
It's true.
It's society running away from its responsibility.
That's true. That's true.
Yeah.
Yeah. Actually, someone said on that tweet, please give the children a break. They're just learning from their elders.
We are the ones who teach them.
It's true.
We are talking about children burning schools, and we are seeing politicians fighting.
Exactly.
When they're at home watching TV, they see politicians throwing verbal abuse at each other, and then you want to blame a young 13-year-old child and say you are condemned into your future. And we have presidents and prime ministers and people who are mature talking the way they are talking on TV. What is the content of our TVs and our radios? So what are children learning?
Yeah.
So let us not condemn children who have diminished responsibility, who are impressionable, who are growing up. Yeah. And then we want to hold them responsibility at 30 for something they did when they were 13 or 14, because we failed as a society. So that is one thing we take away and say, for children, we are going to take that burden. Yeah. And we stop asking ourselves, why are children burning schools? We are the ones to answer that, not the children.
Why are our children,
why are our children burning schools?
Wow, okay.
Yeah.
This is just a yes or no. Does this mean that after the age of 18 now for an adult, once your records are in as a criminal, they can permanently, or actually they must permanently remain on your record?
Yes, they do. Once you're 18, they remain, and it depends. Like in Kenya, criminal record, now when you go to apply for a certificate of good conduct, it's two things. Arrests, which means your fingerprints were taken, and convictions. So that permanently remains. And so when you go for a certificate, that's what responsible authority will give out. This person was arrested, at this time, and this permanently remains unless there's a change. For instance, you're convicted and you appealed, and that was struck out. You are arrested and nothing happened. You can go and ask for your record to be cleaned, so that it expresses the correct position of your criminal and social status. Yeah.
No, finally, a student commits a crime at 17 years of age. They are in Form 4 or Form 3 or whatever. But they're about to turn 18. And a few days or about a month down the line, the case is not done yet. So they spill over into 18 years of age before a verdict or before. What do we consider? Is the record considered to have been done underage or of age?
You consider at the time when the offense was committed.
So if they commit an offense today and they're turning 18 tomorrow,
Yes.
they'll still be good to
Yes.
go even if the verdict was this guy murdered and he should be...
Yes, technically. Technically, it's at the age of the commission of the offense. So if this person was not 18, because the other way of looking at it is saying, okay, she was 18 and 3 days. So why don't we also move it back?
Yeah, exactly.
And
Move it back and say she was just getting into adult.
So for our laws, the Kenyan law, it's the strict chronological age, 18. In other countries, they can have a bit of consideration of the other circumstances, which, bring into play issues of trying to determine responsibility, appreciation of the child's or the suspect's, mind and context and what they did or suspected of doing.
Or the background, whether they were pressured into doing stuff.
And in fact, you bring out a good issue. That's why when you're dealing with children, you find that you work with social workers a lot. You work with children officers a lot. Before courts pronounce their verdicts or their decisions, they want reports from probation officers. I mean, it happens with adults, but more so with children. You want to hear a social background done because you want to understand the social context of why the child did what he or she did. But in strict determination of the age of the of how to deal with the person and charge them, you look at it from the point of when the offense was done.
Thank you so much for keeping it locked to Ask the Experts. And thank you so much, Bobby, for answering our questions.
Thank you for
having me. And we hope
me.
if there'll be any follow-up questions, you'll answer them for us.
I'll be happy to.
Okay, thank you so much.
Thanks.